All right, welcome Employment Law Show. We are back once again. John Scholes here with you, and beside me, as always, my co-host Lior Samfiru, employment lawyer, Samfiru Tumarkin LLP, the most positively reviewed law firm in the country. Reaching out, real simple. I'll remind you throughout the half hour how do you get a hold of Lior and his team. 1-855-821-5900. help@employmentlawyer.ca, or you can simply go to employmentlawyer.ca. Tons of information and contact information there as well. And anytime you want to catch a live stream, I want to mention that YouTube and Facebook, search at ST Lawyers, and you can enjoy those as well. In fact, we'll probably go to something off the live stream a little later on in the show. But today, Lior, 5 things to look for in an employment agreement. No, I think everybody's looking at this going, oh yeah, holidays and how much pay I'm getting. It goes way beyond that. In fact, more important than that. So we're going to get to that here in just a little bit. And some live calls from our long-running radio show. Lior and I, you've been doing that for we're coming up on 10 years pretty soon. We've been on radio across the country, so some calls from that and a whole bunch more stuff. But we got to get to that very shortly. But we always start off with, pal, the week that was, a case of the day. What's going on with you?
Hey, Johnny, great to be back here. More employment law to talk about. There's so many issues. And, last year there were new issues that I didn't imagine the year before. This year there's new issues that I couldn't imagine last year. So whatever the issue is, yeah, I have had time to think about it, to consider it. There are answers. There's solutions. There are laws that protect you, the individual. And on this show, we'll tell you what you need to know if you're facing a workplace problems. Now, hopefully, most of the time, things go well at work. You feel supported, you're treated well, and that's great. But there are going to be times, potentially, when things don't go right, when you're not sure what to do. Maybe you're given an ultimatum. Maybe you feel you're not treated properly or that your job is in jeopardy. We'll talk about all those things always on the show so that you know what to do if things don't go right for you. You'll know what to do, what to say, how to respond. And of course, if you have questions, if you want to have a private chat to get into the weeds with respect to your matter, you can always reach out to me by phone or email, and we'll give you that contact information throughout the show. And to give you an example of a situation that came across my desk actually earlier today, let me tell you something here. I spoke with a gentleman. He has a medical condition, and many days he's absolutely fine. He can go to work. There's no issues. But he has days, because of the medication that he's taking, that he literally cannot get out of bed, cannot get dressed, cannot go to work, cannot do his job. And that had become a bit worse recently. And he had to miss several days, not necessarily in a row, but a few days because of his medical condition. And he told his employer, they knew about it. Well, his employer said, well, wait a second, we never really got anything from you. You've been missing all this work. You tell us you're sick, but we don't know. So because of that, we're going to simply let you go. From our perspective, you keep taking these medical absences without any approval, so you're gone, you're out of here. So the interesting thing, John, here is this person never provided his employer with a doctor's note. He never said, he never got a doctor to say this guy has a medical issue, so sometimes he may not be able to go to work for medical reasons. He simply told his employer, I'm not feeling well, I'm not going in. So the question is, can his employer say, well, we don't have a doctor's note, you're gone? Well, no, they cannot do that. Once the employer knows that there's a medical issue, if they require a doctor's note, they can ask for it. If they don't ask for it, they can't then complain and punish someone for not providing them with that doctor's note. So if the employer says, well, we're not sure we believe this guy, we want a doctor's note, perfectly legitimate to ask for that note. And if the employee doesn't provide that note, despite being requested, then there could be consequences. But because this employer never requested that note, that employer is not allowed to just let him go. That could be a human rights violation, a wrongful dismissal, you name it, it's not legal. So the lesson here is important, certainly for employees. If you're going to be missing work, if you have a medical condition that impacts your ability to do your job, it is a very good idea to get a doctor's note, okay? Your doctor's note doesn't need to say what the condition is, just that there is a condition that impacts you. And for employers, you can't penalize someone for not giving you a doctor's note unless you've demanded that note. So employers have to be mindful, employees, of course, as well. And if you have any questions or concerns, if you're ever in that situation, you give me a call.
You know, it's interesting, too, because when it comes to taking time off for whatever illness it is, sometimes not only employees, but employers get confused with being off for medical reasons and running out of sick days. You know, oh, you've run out of sick days, you've used your 5 or 10, so I expect you back in the office on Monday. That's not the case, right?
That's a great point. And there's a huge difference between the sick days that you have at work and your ability to be off because you're sick. The sick days simply outline how many days you're going to get paid by your employer. It has nothing to do with how many days you can be sick. Your sickness doesn't care about how many days you have at work. If you're going to be sick and you can't work for 6 months, well, that's not a good thing for a medical situation. But from a legal standpoint, you can be off. It's not relevant how many sick days you have. If you have a doctor's note saying that you can't work, you can be off work and you cannot be punished regardless of how many sick days your company provides.
Now, you did mention there, you slipped in when you were talking about that initial doctor's note that it doesn't necessarily have to say what is wrong with you, your diagnosis. So we've talked, and people who have listened to our radio show, of course, and seen this TV show before are probably well steeped in that knowledge. But break down the difference between what that employer is allowed to ask as far as that's concerned, right?
Time and time again, John, I've seen employers say, well, we want to know exactly what your medical condition is. We want to get your full medical records, and you want to know what medication you're on. Well, no. Your employer does not have a right to demand this personal, private medical information. They're allowed to know your diagnosis. No, sorry, not your diagnosis. They're allowed to know your prognosis, meaning, can you work, can you not work, and for how long? That's it. They're not allowed to know your diagnosis. They're not allowed to know what is the condition. What is the treatment? That is personal and private, and frankly, it doesn't matter. Does it matter whether you have a bad back or you're suffering from depression? No. What matters is whether you can do your job. So you can absolutely refuse to give information to an employer that's overreaching.
Again, beyond the show, as Lior mentioned, you want to reach out anytime to ask questions, 1-855-821-5900, help@employmentlawyer.ca. If you go to the website, employmentlawyer.ca, there's a media tab that will give you links from across the country, all the radio shows that we've been doing for years and years. Tons of information there. They're usually an hour long, and they're really good to listen to. You'll learn a ton. Get a lot of phone calls on the shows, too, and we cherry-pick some of them. We play them back here, as you know, Lior, and we talk about them. We'll get to our first call from our long-running radio show right now.
So I've been working in the restaurant for over 30 years. I'm over 50 years old and got a notice that my restaurant will be closing in 8 weeks. And the owner of the restaurant, it's a franchise, well-known chain in Canada. And the owner of the restaurant is saying that we are not entitled to severance.
Yeah, pretty common. Pretty common.
Very common. And for some reason, very common also with restaurants. I don't know why that is. So yes, she may be in a situation where she's out of a job because her restaurant, in this case that she works for, is closing down. But of course she gets severance. By the way, how big the restaurant is, how many employees is completely and totally and utterly irrelevant. After 30 years, she gets a significant amount of severance. Now, John, she got 8 weeks notice. Her employer told her, hey, in 8 weeks, we're shutting down, you're out of a job. So she got 8 weeks notice. That does count towards her severance. But she's owed a lot more. So rather than me just tell you how much severance she's owed, easy to do, let me actually show you how you can find out how much she's owed, how much you're owed. We have our severance calculator tool. All you have to do is go to pocketemploymentlawyer.ca. You see that address on the screen, pocketemploymentlawyer.ca. Use our calculator, our severance calculator, like 2 million people have, and let's see actually how much severance this person gets. We know she's 52 years old. She's been there for 30 years. That's a long time. She was offered 8 weeks. That's 8 weeks that she got as notice counts towards her severance, but she's actually owed 24 months. 24 months. So that's another 22 months over what she's been offered. Now, if her salary is, in the 40s, well, that's going to be probably close to, $80,000, $90,000 extra that she is owed. That's why it's important to use our calculator. You can do that as well. It's free and anonymous, and you may have significant entitlements, a lot more than the company's offered you. And by the way, do not ever believe your company, your HR, your best friend. They tell you that you're not owed severance. If you want to know if you're owed severance, just go to pocketemploymentlawyer.ca.
Tell me this, though. I mean, being a server, I will go back 2 years, say, because that's usually as far as you can go back. If she's got really good bookkeeping and she's kept track of her whatever salary she makes, it's usually not that much of a server's. But the tips fluctuate over the last 2.5 years. Does that get factored into her severance as well for the overall compensation?
Absolutely. That's a great point. So in her case, she has tips. Other people may have commissions or bonuses. All that counts, and it has to be part of your severance. So we would simply look at an average. In her case, we'd probably look at a 2 or 3 year average. And if, let's say, her salary is $20,000, but she makes an extra $10,000 by way of tips, well, then 30,000 is the figure we're going to use to calculate severance. Same thing with your commissions. If you're maybe on 100% commissions or some commission, some salary, and that fluctuates, we will look at an average because your commissions, your variable compensation has to be included as part of your severance.
I want to get to a question here as we roll through this first part of the show, Lior. There's a couple different ways. help@employmentlawyer.ca if you want to send an email along anytime. It might appear on one of the shows. And you get a ton of questions in your live stream. I know you do those all week via Facebook and YouTube. That's at ST Lawyers for that. This question here, first one says, Lior, I've worked in a warehouse for over 20 years, but recently my health has prevented me from agreeing to overtime requests. My boss is insisting they're understaffed and need help. Can I be forced to work overtime?
It's a good question and a common one. And generally speaking, the answer is no. Unless you sign an employment agreement that allows the company to require you to work overtime, in most cases, you cannot be forced to work overtime and you cannot be penalized for refusing. So the answer is no. But in this case, there's something else this person can do. They have a medical condition that impacts their ability to work. Get a doctor's note saying for medical reasons, I can't work overtime over the next however long. By doing that, if your employer still penalizes you, not only would that be a wrongful dismissal, that could be a human rights violation as well. So a doctor's note, remember, always your best tool if there's a medical condition. And no, you cannot be forced in most cases to work overtime.
What is the flip side of that coin? Meaning you've worked the overtime, maybe you've even been told not to, but you had to do it to get the job done. Can you still claim for that? Do you still get paid for it?
Happens often. I had to work. I had to stay late. All week I worked extra hours because I had to get the job done. My employer says they're not going to pay me because they didn't ask me. No. If you worked the hours because they needed to be done, your employer has to pay you. They don't get to avoid it because they didn't ask you. They don't even get to avoid it if they specifically told you not to work it. If you worked it and it was legitimate, your employer must pay you the overtime.
We'll take a short break. When we come back from the break, 5 things to look for in an employment agreement. In the meantime, write this down, 1-855-821-5900, the number. Email to send along, help@employmentlawyer.ca. We'll continue. Lots more employment law shows coming up. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back, Employment Law Show. So good to have you along with us this week. Lior Samfiru, beside me, of course, employment lawyer. Samfiru, Tumarkin, LLP, the most positively reviewed law firm in this country. So feel rest assured you can reach out anytime and get some great advice and go forth from there. 1-855-821-5900, the number. help@employmentlawyer.ca. Lior, let's get into this. 5 things to look for when signing or at least looking at an employment agreement. As I mentioned off the top of the show, this goes way beyond how much holidays you're going to get and how much you're going to get paid. There's things in there that you really need to have a good look at. And if you're ever dumbfounded by it, reach out to Lior, send him the agreement, and he'll have a look at it for you. First thing is this, a termination clause or terminology regarding an employee's right to severance pay. Big one.
That is the big one. I am actually going to say more than that. It's the biggest one.
Right.
And the reality, as you said, John, when people look at a new job offer letter, I just got a job offer, a new employment agreement, they look at the salary, right? They look at how many vacation days they get a year. They may look at what the bonus is or how many sick days. Obviously, that makes sense, and those are important terms. But there are potentially more important terms than whether you're getting 2 or 3 weeks vacation. We're going to talk about those right now. And the first one, and it's the first one that I look at when I review an employment agreement, is there language there about termination? And here's why. What an employment agreement can do is to significantly limit your future severance. And I mean significant. It can be the difference between down the road you getting 24 months pay and getting 8 weeks pay. It could literally cost you tens, if not hundreds of thousands of dollars. So if your employment agreement contains language dealing with termination of employment and what you would be owed in the event of a termination, usually that is bad news. Your employer would only include language like that to limit your future severance. So be careful about that. In an ideal scenario, your employment agreement does not address your entitlement on termination, in which case the law simply takes care of you. You can negotiate those terms. I'm happy to help you with that. But if there's anything limiting your severance, trust me, at some point it's going to cost you a lot of money.
Okay, second thing to look out for when looking and signing employment agreements, these could actually be red flags as well. A clause that permits an employer to make changes to the terms of the employee's job. Yeah.
So you've heard me on the show for years saying that an employer does not have a right to make significant changes to terms of employment. Your employer cannot just relocate you, demote you, reduce your pay, change your job. They don't have a right to do that unless you've given them that right in an employment agreement. So what some employers are starting to realize, wait a second, why not build in the flexibility in the agreement that says, yeah, we're going to pay you $80,000 a year, but we have a right to change that. Or yes, we're going to hire you as our marketing manager, but we have a right to change that. So if your agreement gives the employer that power, your employer can essentially do whatever it wants. It can reduce you to part-time. It can stop paying you your full salary. It can take away your commissions. It can do all those things. So you want to be very careful. Don't agree to terms that give the company the right to take your job away from you, essentially. Never do that.
Third one is this, and up until about 3 years ago, nobody would know what this means. Now this one's absolutely got a front row seat, and that is language that allows your employer to implement temporary layoffs. How about that one?
So an employer does not have a right, and I know many people are surprised by this, but an employer does not have a right to put you on a temporary layoff. If you've been put on a temporary layoff, you can choose to treat that as a termination and make your employer require them to pay you severance. So an employer doesn't have a right to do that unless you gave them that right in an employment agreement. So if your employment agreement says, we have a right to lay you off temporarily, guess what? Your employer can put you on a temporary layoff at any time for months at a time, and there's nothing that you can do about that at that point. So you have to be very careful with that. You never want to agree to a term like that. Think about how you work that way. You work for a few months, you're off for a few months, you can't support your family that way. It's not a good situation to be in, but employers are starting to use that. So that's why you have to be aware of it.
What we're going through here right now in this segment is things you should be looking for in an employment agreement moving forward. 5 of them, actually. Number 4, classification or title as an employee or an independent contractor. So many people have no idea about this one.
So people get misclassified as contractors all the time. An employer may say, well, we want to save money on deductions and, we don't have to worry about EI and CPP, so we're just going to call you an independent contractor. Well, no. If you have a regular job, but you're being called, your agreement says that you're an independent contractor, you're doing something illegal. And there's consequences to that. You could be audited, you could have to pay fines and penalties and back taxes, bad situation to be in. So if you know you're hired as an employee, but your employer is calling you an independent contractor, that's not legal. It's not legal for them, it's not legal for you, and you shouldn't agree to that. And of course, if you're not sure, are you truly a contractor? Are you really an employee? Have you been misclassified? Well, that's why I'm here for. Call me and let's talk about it.
We'll get to one more of these, pal. Non-compete or non-solicitation or privacy clauses regarding clientele and data. How about that?
So you may start a new job, being optimistic and of course thinking all the best, as you should. But what if there's a term in that agreement that says, hey, if we ever let you go, if you ever leave, you can't work for a competitor in the industry for 3 years and you can't talk to your clients? Well, that could be hugely problematic. Now, that may or may not be enforceable. In many situations, it's not. But forget about that. The real question is whether your employer is going to try to enforce it, take legal action against you. So bottom line is this. If you're not going to be prepared to live with what you've signed, don't sign it. Okay? You can't sign something thinking, well, I'll deal with it later. Maybe it's going to be unenforceable. That's just an invitation for disaster later on. So a non-competition provision is hugely problematic. It prevents you from earning a living. Same with non-solicitation in certain situations. So you have to be very mindful of those. And by the way, John, the reason we're mentioning all these things here is not just to scare people. You can negotiate these terms. And in fact, it's not even difficult. I do that with my clients all the time. So if you have these unfavorable terms in your agreement, and there could be more, we've just given you an example of 5, there's many more. Let's talk about it. Let's understand what it does, and let's talk how we negotiate those terms without you risking losing your job.
Got a couple minutes here before we break. Let's get to another phone call from one of our video shows, Lior.
With regard to 3 months probation period, if an employee has been let go right at the 3 months, what would that be as far as pay in lieu of notice? The employer is saying the 3 months probation period, if we let you go during that 3 months, we don't owe you nothing.
The old probation period.
Yeah, and very common mistake, by the way, that employers and employees make. So here's how probationary periods work. The only time an employer is allowed to let you go in the first 3 months without paying you anything is if you sign an employment agreement. Hey, back to the employment agreement.
Yeah.
That allows them to do that. So if you sign an employment agreement saying your first 3 months are probationary, and during that time, we don't have to pay you anything if we let you go, then that's the case. Your employer can let you go in the first 3 months without paying you anything. But it's not automatic. It's only if you sign something that says that. Otherwise, if you never sign that, if you're let go, even after a month or a few weeks, if you're let go, you're owed severance. And you're going to be surprised by how much you're owed. You could have been working somewhere for 3 months, and you could easily be owed 3 months, 4 months, even 6 months of severance. Yes, even after 3 months. So remember, probation and probationary periods are not automatic. They only exist if you sign an employment agreement. So, hey, this is the 6th term, if you will, that you have to be mindful of, especially if you're going to leave a secure job to join another company, right? Don't agree to be on probation. Why agree to be on probation if you're leaving a secure job, if you're recruited away from a secure job? And remember, it's not automatic. Otherwise, severance is still owed.
All right, short break. Lots more to go, though, so stick around. We'll get another phone call from one of our radio shows. In the meantime, write this number down. Keep it with you, 1-855-821-5900. And I'll give you the email address again anytime to shout out to Lior and a member of his team. help@employmentlawyer.ca. We'll continue. This is the Employment Law Show. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, welcome back. Employment Law Show. Still a few minutes to go here. Again, reaching out beyond the show is simple. help@employmentlawyer.ca through email. And the phone call always works, 1-855-821-5900. A wonderful team Lior has with him to answer your calls and any questions you have moving forward. I mentioned the radio shows across the country, employmentlawyer.ca, the website. There's a media tab there. You'll find one to listen to near you. Phone call number 3, I guess it is, Lior, for today's show. Let's get to it.
I was working for a company for 10 years. Other director took over, and when he would talk to you, he wouldn't talk to you. He would yell and swear at you all the time. And then they came up with a reason to terminate me, and I didn't agree with their dismissal proposal there, so I didn't sign it. But they didn't give me any severance.
How long did you work there for total?
10 years.
What kind of a job is this, and how old are you?
It was in addiction recovery, and I'm 62.
Well, he did the right thing by not signing, because remember, 90% of people, and I mean, it's probably more than that, but let's call it 90% of people, when they are let go, are owed a lot more severance than what they've been offered. So he was let go. By the way, that termination may be illegal. He says he was harassed. So there may be a human rights issue here potentially. There could be a reprisal, which is where you get punished for standing up for your rights. But there certainly is a severance issue. And he hopefully is a good example for all our viewers now that if you're let go, you're going to get that paper to sign. You don't sign it. You don't sign it till you call me or you use our severance calculator. So let's use that severance calculator right now to see how much severance this person is owed. So I'm going to once again go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. You'll see our severance calculator there, completely free, completely anonymous. Let's see how much severance this person is owed. So we know he's 62 years old. He's an addiction and recovery worker. He's been there for 10 years. He hasn't been paid any severance. Well, we see he's owed as much as 16 months, somewhere between 14 to 16 months of severance. That's what's at stake for him. That's easily going to be into the six figures for this person. That's why it's important for him not to sign off. He could have been offered $10,000, and he can't do that and accept that inadequate offer. Yep. Same with you at home. Go to pocketemploymentlawyer.ca.
I did mention the live stream, Lior. You host those several times during the week on Facebook and YouTube as well. At ST Lawyers is how you search for that. And tune in. Always a chance to ask questions as well. We'll get to one here with the remaining couple minutes, Lior. Says, how much time do I have to accept a severance offer? My former employee insists that I have the rest of the week to decide before they change their original offer. Pressure's on, right?
Well, it's exactly that. It's a pressure tactic. Let's be very clear. Every single severance offer, everyone has a deadline on it. It's an arbitrary date that the employer says. You have to accept this by Friday or by Monday or whatever the date is. And why is that there? Well, it's there as a pressure tactic. It's there to make the employee think, oh my gosh, there's this deadline, and if I don't accept it, I'm going to lose out. I'm not going to get it. Wrong, okay? That deadline is meaningless. Your legal rights do not expire on that deadline, at Friday or Tuesday or whatever that is. In fact, your legal rights do not expire for 2 whole years, 2 years, okay? So it's because of that pressure tactic is there because your employer doesn't want you to take your time and get advice and understand that they owe you more. They want you to sign it now so that they can pay you a lot less than what you're owed. Well, if you're watching our show, you know better. You know that when you're staring at that severance package, you're not going to accept it. You're not going to fall for that pressure tactic. And you're not going to then call me saying, hey, I signed it. What can I do? Because then I can't help you. So call me if you lose your job before you sign, before you even think about signing. Go to pocketemploymentlawyer.ca. Use our severance calculator. If you don't like me or you don't like the Pocket Employment Lawyer, then fine. Go to another employment lawyer. But do not sign in any situation before you've done that.
I guess most employers are assuming that on average 9 out of 10 people don't know that, and they're going to say, oh geez, I better have this thing back by Friday. I want my money, and they'll sign off, right?
It is a good assumption because the reality is most people don't know it. Most people are going to do exactly what you've said and what I've been saying. They'll sign it because they don't want to lose. They think they'll lose something if you don't sign by the deadline. So if the company's going to let go of 10 people and they're going to make them all bad offers and they're going to give all of them deadlines, 7 or 8 of them are going to sign, okay, because they don't know any better. And sure, yeah, the other 2 are going to say, no, you owe me more. They're going to get more, but it's still good odds for the employer. Well, I can't do anything about people that sign, but if you're watching the show, hopefully I've gone through to you and you know better than to sign. You're going to be one of the 2 or 3 people that don't sign and get what the law says you should have.
And really, a sophisticated employer will know that you might want to go talk to a lawyer. In fact, they'll invite you to do so and get back to us, right?
A good employer should do that, and no employer is going to be surprised when you call them on the fact that they owe you more severance. You have to do it right, which is where I come in.
And that'll do it for another show. Thank you so much for tuning in. To reach out to Lior anytime, again, pocketemploymentlawyer.ca, wonderful website, 1-855-821-5900, or email us help@employmentlawyer.ca. We'll catch you next time.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.